Now, there's a danger that when one's first asked to look at procurement law, and I think all of us, when we start at procurement law, the first thing we're tempted to do is go and get out the legislation and read that. And we start in the middle of this and look at the directives. But if we do that, we really miss the way the whole law is properly structured. The directives are not a code. They're just directives from the EU legislator to member states about the way in which the law should be developed. There is rather more to be said about that, and we'll come on to it in a moment. There are a number of sources of law other than the directives. Above the directives, you have what I've called here EU primary law, in other words, the treaties and the general principles of law. And increasingly, the key aspects of procurement law, as we see them in the cases developing in the UK courts, are not so much the specific rules of the directives, although they're obviously relevant, but those general principles and the interpretation of those general principles in the case law of the European Court of Justice. So we've got the key principles which are actually now repeated in our UK legislation are the principles of equal treatment of tenderers, the principle of non-discrimination, and the principle of transparency. Now, the problem with open textured principles like that is that they sometimes clash. You can sometimes have a situation where to treat someone equally, you might have to be not quite transparent. And so one of the things the courts have to deal with is how to reconcile those rather open textured principles when you're actually trying to deal with them in the sense of rules. But the way I've tried to conjure this up in this picture here is to show that the ECJ case law really has a direct influence on UK domestic legislation. Our regulations, the 2006 regulations in the public and utilities sector, have to be seen primarily in the light of that case law, and it's that case law more often than not which actually drives the way we interpret procurement law. It's also true to say that both the EU and the UK procurement bodies, in the UK, the Office of Government Commerce, in the EU, the relevant Directorate General, they have both been prolific in producing documents with various names, guidance, recommendations, communications, decisions. We don't have time today to go through the sort of hierarchy of those and work out which might be more important than others. I've just referred to them here as soft law. Those documents are important, although sometimes, theoretically, they are of no legal value. But even with the documents that are of no theoretical legal value are often treated by national courts as being at least of some interest when trying to deal with hard problems that turn up.